external injuries first.
Yes.
And welcome back to the Law and Crime Network this Friday afternoon here in New York City, where we're covering the case of former Marine Jason Riley King out of California. I'm Caroline Polisi, and I'll be here with you this afternoon. Now, court is not in session today in the Jason Riley King case, and it will not actually be in session until Tuesday of next week because of the holiday, but that's okay because we are catching you up on what happened thus far in the case. It's been a really unique trial for us here at the network, specifically because of this issue that the prosecution chose to charge King with 2 counts of second-degree murder instead of vehicular manslaughter, which is what you might typically see in a case like this. In defense's opening statements, they admitted that Mr. King was guilty of a DUI and manslaughter, but the reason that the prosecution is charging him with murder is because 8 days prior, allegedly, he had attended this mandatory seminar on his base that included a lengthy discussion about sort of the perils of drinking and driving. And he blew about a .14 on his breathalyzer an hour and a half after the accident. And we heard that hospital interview during his trial, and boy, oh boy, he did not sound like he was in his right mind. We also want to remind viewers that we are gearing up for a new trial here on the network. Very exciting. Jury selection is still underway in the death penalty case out of Florida, and that's the case against 49-year-old William Woodward. Prosecutors have charged Woodward with 2 counts of premeditated murder and 1 count of attempted premeditated murder stemming from an incident that occurred 5 years ago. Now, Woodward does not deny that he opened fire on his neighbors that evening, but he's claiming self-defense. And because, you guys, this is a case out of Florida, there are stand your ground issues. Now, prosecutors are describing this event as a vigilante attack, saying there's no way this was self-defense. This guy is a murderer in cold blood. Trial in that case is going to commence next week with openings likely on Tuesday. And of course, we will bring you gavel-to-gavel coverage here on the network. And I want to play a short preview of that case for our viewers now. Take a listen.
Labor Day weekend 2012. What should be barbecues, fun, and celebrating turned into murder. William Woodward of Titusville, Florida, is accused of shooting and killing 2 neighbors and injuring a third. And it was all captured on surveillance footage. The man who prosecutors say dressed in camouflage and hid in the bushes for this surprise attack is now claiming self-defense. His defense attorneys say Woodward was provoked for months and that the community supports his actions. And that's not all. Reports indicate that Woodward, who is a war veteran, may suffer from PTSD and a brain injury. Stakes are high in this case as Woodward could face the death penalty.
All right, that's the William Woodward trial we're planning on covering here at the network next week. You won't want to miss a second of it. Coming up today here on the network, a little bit later at 1 p.m., I have a very special segment for you on the Russia investigation. You guys, this is the story that will not go away. It looks like we're gearing up for a Mueller-Trump one-on-one. I'm going to be talking with special guest Bradley Moss joining me here to discuss that issue and many more later, so tune in at 1. You won't want to miss it. But now I want to get us back to the case at hand. We've been covering this week for you out of California, and that's the case of Jason Riley King, 23-year-old Marine accused of driving the wrong way while driving drunk on a highway, causing a head-on freeway collision, tragically killing 2 UCSD medical students and injuring 3 others. King is charged with second-degree murder, and the victims in that case are 23-year-old Madison Cornwell and one of her passengers, 24-year-old Ann Lee Baldock. I'm joined today with a very special guest. We're very excited to have him here with us, Nima Haddadi of the H Law Group. Nima, thank you so much for being here with us today.
My pleasure.
Not only are you a very distinguished attorney in your own right, but you also represented Mr. King throughout the preliminary hearing in this case. Is that right?
Yes, it is.
Wow. So, without getting into sort of issues of attorney-client privilege, obviously, I want to start out by asking you about, there was a potential plea deal on the table here, was there not, by the government? Can you take us through what the government was actually offering in the initial stages of this case?
Well, at the beginning, they didn't even give us an offer. The evidence was trickling in it didn't all come in one big bunch. So as it came in at the beginning, there was no offer. We represented Mr. King through the preliminary hearing, and the offer did keep getting better and better. And at the end, they came back with us, and they didn't want to actually modify the charge of murder. And that's when we said, we should take this case to trial because it just doesn't make any sense.
Interesting. So I read reports that King rejected an offer to plead guilty to second-degree murder and DUI with a sentence of 15 years to life plus 8 behind bars, which, I mean, as any defense attorney knows, I mean, that's not a very good deal. I mean, I can see you taking sort of a plea deal if they had, bumped the charges down to manslaughter, but you're saying that that was never on the table. The prosecution was had such blinders on in this case that they weren't even willing to sort of barter with you on a plea deal?
No, they weren't. From the beginning of this case, it was strange. The arraignment was held in the hospital. And then 5 minutes after the arraignment finished, there was a full-blown press conference right outside of the hospital.
Whoa. Hold on. I'm shocked. Okay, I've never heard of this before. Actually, I have heard of it before, but how does one conduct an arraignment at a hospital, at the hospital bed?
They bring a judge in, they bring a bailiff in. Our client was sitting there, hospital-ridden, broken bones, and they did the arraignment right there. Was
he still intoxicated?
No, this was, it was a few days after what had happened.
Wow. Is that sort of common protocol in your state?
No, it's not, but it seems like in this case there's a lot of things that happen that aren't very usual.
So tell us about that. I know there's an interesting story behind the prosecutor. Tell us a little bit about that.
Oh yeah, so this isn't just your ordinary courtroom prosecutor. This is a specially assigned prosecutor in a special unit that handles cases like this. Very seasoned attorney, aggressive and good prosecutor, but she knows what she's doing. Like I said, right after that arraignment, within minutes outside, there was a full-blown press conference. And
what did they say at the press conference?
She talked about the arraignment, and she talked about how what she thought was going to happen with the case. She said that they were going to move forward aggressively with the prosecution, and that's exactly what they're doing.
Okay, so again, without getting into sort of attorney-client privilege issues, take us behind the scenes of sort of what's going on with you and your client in terms of what types of conversations you're having about strategy about the case at that point in time. Once you realize, for example, that, look, the prosecution's not backing down.
Of course. The thing to understand is, so my client didn't have any type of criminal record at all. This was a Marine. Had never gotten in trouble before. All this was new. He was from a small town, his family, no idea about what was going on. And then on this side, you have an aggressive prosecutor that is overreaching on charges. Murder, doesn't even talk about any type of manslaughter charges. It was terrifying. It was terrifying. And on top of everything, our client had injuries. He had to have a neck brace the entire time. He couldn't even support the weight of his own head. And it's a terrible situation.
Yeah, we're all familiar now at this point with that sort of infamous photo of Mr. King wearing the big neck brace while in court. Now, I heard reports that he also rejected a prosecution offer to plead guilty to gross vehicular manslaughter while intoxicated, DUI, and attempted murder. Again, that still carries with it a sentence of more than 25 years in prison. Is that true as well?
We weren't a party to those offers. Again, we didn't get any offers other than murder. There was no other offers on the table other than murder.
Okay. So King did eventually file a motion to dismiss in this case, arguing that a murder charge obviously was too severe, and the prosecution had based the murder charge on the fact that King underwent this training about the dangers of drunk driving as a Marine, because he was warned multiple times not to drink and drive. What's sort of your feeling on this? And we were talking a little bit off camera about maybe some things that our viewers don't know about whether or not the defendant actually attended those meetings.
Sure. So the stand down that took place, it was a one-time class that they came in and they talked about safety issues. It wasn't just about DUIs. It was about numerous things. I believe gun safety, DUIs were a part of it. But it was a very small portion of the actual training. And the thing that's actually strange is on that day, Mr. King actually came in late into the stand down. So he wasn't even there for a part of the actual stand down. So the prosecution has a tough time placing him at that stand down. When did he get there? He never even signed it, the sign-in sheet. These are all issues that the prosecution is going to have to deal with.
Interesting. Thus far, we haven't heard much about that. We've heard a lot about the actual content of the stand down, the content of the information relayed there, which of course, what's so interesting about this case is, again, it's a slippery slope. Just because he attended, or maybe not, this meeting, it's not like, we all haven't been lectured at one point in our lives or another about the dangers of drunk driving. Therefore, the question is then, do you hold everybody accountable for murder in these types of situations? And I want to talk a little bit about your state and sort of the philosophical underpinnings of the law surrounding DUIs. Yesterday we had on Adam Sostrin here on the network talking about who he defends against DUI types of cases, and he gave us some fascinating insights into the California system when it comes to DUI prevention. And so I want to talk specifically about this case, Watson. Tell us a little bit give us some background on that issue.
So even going back to that, the stand down, that's a big issue for the prosecution. They're really trying to sell this thing as a educational course in which Mr. King took. As I said, the whole stand down, it was pretty short. Maybe 15 minutes of it at most was in regards to DUI safety. Again, they don't even know if Mr. King was present at that time, and the only thing that was really said is you shouldn't drink and drive, as everyone is told from a young age, but they didn't get into the details of the actual Watson advisement, which talks about putting a person on notice that, if you drink and drive, you could be charged with murder. It doesn't make sense. It's a very, very far stretch at best.
Right. So that's kind of the argument the prosecution is making here, that as I understand, in California, a first offender with a DUI gets this Watson charge, basically signing away his or her rights if it comes to a second offense, saying that they can and will be charged with murder thereafter. And the idea that the prosecutors are putting forth is that sort of this stand down that the defendant supposedly took part in is really much like a Watson advisement. Therefore, this can be treated as sort of a second offense, and they're bringing in the charge of second-degree murder. I want to play our viewers a clip of Sergeant Robert Bowden. He's part of the U.S. Marine Corps, and here's his testimony. He's talking about these weekend safety briefings, so specifically one that happened in May of 2015, about a month before the incident occurred. And his testimony is that prior to every weekend, they would give these young Marines safety briefings on a range of different topics, in general, but drinking and drug use were always covered every single week, he's saying. So take a listen to sort of how he characterizes that, and we'll be back to discuss.
For lack of a better term, yes. We would often, some of the more senior leadership, we would take turns giving it weekly.
And what do you call it, Liberty or weekend briefings?
Weekend safety brief.
And you mentioned that other people take turns. How do you decide who's going to give the weekend safety brief?
Well, for instance, if it's myself and another sergeant, depending on who's on that given shift, sometimes depending on who's good at public speaking, or if they just have different areas that they would like to cover, kind of like a lessons learned kind of mentality to pass that information along as an extra, if that makes sense. It's not really one individual necessarily always giving it. It's more like a conglomeration of the leadership passing forth knowledge for the weekend.
And on any given shift, if there's about, dealing with the time frame around May of 2015 and the months before then, how many people are supervising that group of 60?
Well, on each shift, there's one individual who is primarily in charge as a non-commissioned officer level, but then they will have there will be other non-commissioned officers assisting them as well with their duties. So to answer your question, I believe back in May 2015, with the number that we had, I believe there were about 3 non-commissioned officers.
On every shift?
I'm not exactly sure on that.
Now, you mentioned that a weekend safety briefing, how often are those given out?
Every weekend. Well, prior to the weekend.
Now, who determines what's discussed at that meeting?
So the staff NCOs, the gunnery sergeants, the staff sergeants, and the officers in charge will pass forth, to the NCOs what specifics to cover, but the general terms are always covered: drinking and driving, drug use, off-limit areas throughout San Diego, what you can do, what you can't do. Those are always the consistents covered every week.
When you say that DUI is covered every week, what do you mean?
We cover not drinking and driving, not driving while impaired. We always ensure that people had their Arrive Alive cards, that they basically had a plan, and that they knew that there was a zero tolerance policy, and if they found themselves in trouble, that they could call somebody.
How often during those Liberty briefings did anyone discuss what could happen if someone got a DUI?
Well, I know for every single one that I gave, I personally covered it.
What exactly did you say?
Anytime I would cover one of those briefings, I would inform everybody of a situation that happened to me when I was a Lance Corporal in Pensacola, Florida. I lost two of my best friends to a DUI, so that was always a soft topic for me.
When you say that you were a corporal or the sergeant of the BFMAT 101 squadron, at any point in time were you kind of the shift supervisor for the defendant, Mr. King?
I believe at the time that I took that position was right when the defendant was moved into the tool room work center. I would have been right in that immediate time frame.
Do you know during that time frame, say beginning February of 2014 through May of 2015, were there ever times when you gave a Liberty briefing in that time frame?
Yes, absolutely.
And was there ever times when the Mr. King was at any of those Liberty briefings?
I can't say for certain or not, but if he was on one of my shifts, then he would have been, unless he had a reasonable excuse for being absent.
And how would you know whether or not he was on your shift?
Well, every supervisor has a list of all the individuals placed on their shift, along with phone numbers. But back in 2015, I don't recall if he was or wasn't at that given time.
And you can't actually remember seeing him at one of your weekend briefings?
Not on my immediate ones that I'd given personally, no.
During that time frame, February of 2014 through May of 2015, how many of the Liberty briefings would you say that you gave during that time frame?
Could you repeat the time frame again?
Sure. February 2014 through May of 2015, so about 14 or 15 months.
Probably close to around 70 or 80.
7 or 8? 7 or 8?
I said 70.
And were all of those briefings for the BFMAT 101?
No, ma'am, not for VMFAT 101, just for my immediate work center, just power plants division, on my given shift, not the entire.
Power plants division?
Power plants, sorry,
Power plants.
power plants, yes.
And at that point in time, was Lieutenant Mr. King, he was assigned to that division?
I can't state for certain, but yes, I believe he was.
Now, I'd like to take you back to the beginning of May of 2015 regarding a safety stand-down. We talked about Liberty briefings.
All right, so that was testimony from Sergeant Robert Bowden. I'm still joined with Nima Haddadi of the H Law Group, who represented Mr. King. And I just want to get your thoughts, Nima. You heard this testimony there about these sort of weekend briefings that he would give to Marines prior every weekend. They would give this safety briefing on different topics in general, but drinking and driving was one of the topics that was always covered. And he explained there that they would want to ensure that everybody had a plan in terms of, if they found themselves sort of out with no way to get home. They discussed the zero tolerance policy, and every single one, he says, that they would talk about what would happen if you were engaged in this type of situation. So what are your thoughts about that?
First, I don't even think it makes any sense where they would talk about the same thing over and over every week. It's my understanding that very short, they talk about you shouldn't drink and drive. It's wrong. There's a zero tolerance policy. That's it. But it's so crazy for me that the prosecution is trying to equate these stand downs, that they're unregulated. No one even knows what really is said at these stand downs, because there isn't really a form. They don't stick to statutes or anything like that particular, but they're trying to equate this to an actual Watson advisement, which takes place in court. And the way a Watson advisement works is during sentencing, when a person's up there, defendant, the judge sits down and reads a specific document, which pretty much says that if you drink and drive, we're putting you on notice that if you drink and drive, you can be charged with murder. The very fact that that doesn't take place should be enough to say, you know what, there wasn't a Watson advisement. This person had no idea that they would have been charged with murder in this particular situation. But the prosecutor is stretching. Now they're trying to equate different things, and that kind of takes away from the actual Watson advisement. The whole point of a Watson advisement is to make sure that the defendant actually understands that they can be charged with murder. Now the prosecution is sitting there going, okay, well, we're going to use other factors in life to try to come up and take the place of that Watson advisement when we don't have it. It's just wrong, especially when you're dealing with something like murder, a Marine that has zero history of any type of criminal activity, trying to serve the country. It's just sad.
Yeah, I see your point. Let's talk about the elements of a second-degree murder charge. It requires that the foreseeable results of your act are that someone could be killed and that you intentionally engage in that behavior. And so the form for I think the Watson advisement uses the foreseeability part of those elements. Sort of that's the sort of element that the prosecution, if you get the Watson advisement, the prosecution sort of already gets to have that foreseeability element sort of checked off in terms of meeting all the elements of the crime. Here, they're still going forward with that second-degree murder, and so the idea, I suppose, is that because he did have these extensive advisements, that the consequences of his actions should have been, and in fact were, reasonably foreseeable to him at that time. Is that where you think they are going to get, the prosecution is going to get into trouble here?
That's what they're trying to do. They're using that. They're trying to piece things together and muddy the waters. They're sitting there, they're using this. They're trying to say, okay, the bar owner, the bar where Mr. King was that night of the incident, he told him as well, you know what, you shouldn't drink and drive. They're saying that his friend told him as well. They're piecing together numerous things to get that advisement in. Mm-hmm. It's not there. Mm-hmm. There's a lot of holes. There's a lot of issues with everything. The prosecution's going to have some trouble. Mm-hmm. The elements just aren't there. So
you were his defense attorney, no longer, but if you're giving the closing statement, we've yet to see if they're going to put on a case, but what do you go into the details of that night, or do you sort of pound, the old sort of law school adage, when you have the facts on your side, pound away at the facts; when you have the law on your side, argue the law, and if you have nothing, just pound on the table and yell really loudly. Which one are you doing in closing statements?
The truth. I feel like with this case, it's all about the truth. Prosecution doesn't have a case. Murder is definitely the wrong charge, and that's where the defense needs to hold tight. They need to sit down, and every single piece of evidence that the prosecution is going to put forward has issues with it. The stand down, well, was he even in the stand down? When was he there? Did he hear the information in regards to the DUI? As far as the friend coming in and telling them, hey, you shouldn't drive, did that really happen? Mr. King was sitting outside of that bar waiting in front of next to the security guards. He was out there for 15, 20, 25 minutes. Nobody said anything to him. He was outside in the parking lot, 25, 30 minutes, just sitting out there in his car. Nobody came up to him. There's just issues that haven't even come out yet that I think the prosecution is going to have a really tough time with. And I am really hopeful, and I believe that based on the truth and justice and everything, they're not going to be able to convict them of murder.
I just want to clarify a little bit for our viewers, because that's not the story we've been hearing so far in trial about sort of how it went down that evening. Can you clarify a little bit? You said he was waiting 15 minutes at the bar. I mean, according to what we know, apparently the bartender told him, look, you're too intoxicated to drive. Is that not the case?
No, that's not the case. So during the preliminary hearing, the actual bar owner came out. There's footage of Mr. King sitting outside in direct view of the security guards, and he's just sitting there 15, 20, 25 minutes waiting for his friend. Nobody says anything to him. Not one time does anyone come up to him and suggest, you know what, maybe you've had too much to drink, maybe we should order you a cab. Nothing like that. It just doesn't make sense. If the bartender did really go and say, you know what, maybe you shouldn't drink anymore, I believe that he would have probably walked over to the security guard and said, you know what, this guy's way too intoxicated, if he was concerned. Based on the fact that the video footage showed nobody from that establishment walking up to him, it's very hard for me to believe that actually took place.
It's very interesting. Okay, but Nima, you have to admit, did you hear his hospital interview? You have to admit, I mean, the guy sounds wasted in that interview.
You know, the thing is, he was in a horrible car accident. Brain damage. I'm not trying to make excuses, but how do we know that it was the alcohol? I know that the actual alcohol had an impact, but the car was totaled. It was just such a bad car accident. There was definite trauma there. How do we know how much of that attributes to the alcohol? We don't.
Yeah, that's a very good point. That's a very good point. One that I, quite frankly, hadn't taken into account. So, you know, hopefully the defense will bring that up. I just want to talk to you a little bit about sort of these policies in general. I'm assuming that you defend against DUI cases all the time. Judge Joan Weber agreed in part with the defense initially, saying that this case was a close call for a murder charge. She said, I do think that to extend this to anyone's, to extend this time to anyone that's had any sort of class on DUIs could be a very dangerous situation. I do not think that's what the law intended. Do you see this as sort of a groundbreaking precedent in the state of California? And what do you see may happen down the road if there is a conviction for this charge?
100%. What they're doing is they're taking away from the Watson advisement. If you don't need the Watson advisement anymore, then notice will always be there. Everything will be foreseeable. In elementary school, if somebody tells you, you know what, you shouldn't drink and drive, they might use that as the notice. It's terrible. Case law establishes the Watson advisement is needed, but for some reason, the prosecutor seems to think it doesn't, and it shouldn't apply in this case. It's sad.
And why do you think the prosecutors took such sort of visceral offense to this incident? Do you think there's something personal here, or why do you think they chose to sort of use this as sort of the spotlight issue?
You know, it's very sad. My heart goes out to the victims in this case. I understand medical students. But that being said, it just doesn't make any sense. The law is the law. And this isn't a murder case. It's black and white. It's very clear. Why is the prosecutor so aggressive with this case? Is it because it's a case in the public? Public has taken note of it. I don't know. I hope that's not the case. But whatever it is, it's just very odd. I've never seen the DA's office go after somebody with charges that are this overstretched, saying the least.
Interesting. Well, you know, one of the issues that Jesse Weber, another host here, was talking to a guest we had on earlier is about sort of the line between anger, outrage that the jury may be feeling, and sadness, really, for the tragic loss of these two medical students' lives. I mean, that sometimes gets overlooked in this debate, but they will not be forgotten. We will hear testimony about about their lives. Right now I want to show our viewers a clip of one of the survivors of the accident, Yuki Izuki, on this next clip. He's testifying about sort of the lasting ramifications that he has had to endure since this accident. Take a listen and we'll be back with Nima.
Mr. Izuka, where do you work and go to school?
I am currently working at Scripps Mercy and I go to school at UCSD.
What do you do at Scripps Mercy?
I am currently a medical student, and so I am helping out the team with patients there.
You also mentioned that at UCSD you're a medical student, is that correct?
Yes.
What year of medical school are you?
I'm currently a third year.
So in your third year, is it fair to say that you're doing like a practicum rotation?
Say that again?
Because you're in your third year, are you doing like a rotation in hospitals? Is that fair to say?
Yes.
Mr. Zuki, you've had some medical issues in the last 2.5 years. Is that fair to say?
Yes.
Do you remember anything about the night of May the 15th, 2015?
No.
What is the first memory that you have after that date?
The first memory, I guess I would say the first memory that I have would be being at the rehabilitation center and being lost and frustrated about the fact that I didn't know where my room was.
Now, since that memory of the rehabilitation center, is it fair to say that you've had memories or you've been able to research kind of what happened to you from the night of May the 15th of 2015?
Wait, so what was the question? I'm not entirely sure.
Since the night of May the 15th or into the early morning hours of May the 16th, 2015, is it fair to say that you've had the opportunity to go back and kind of piece together what happened
Yes.
before your first memory at the rehabilitation center?
Yes.
And how did you go about piecing that all together?
I spoke with family and friends to find out exactly what happened.
And did you learn, in speaking with people, that you stayed in a hospital?
Did I learn from the people that were in the hospital at the time?
Did you, at some point in time, did you learn that you had to stay in a hospital because of some injuries that you had?
Yes.
Do you know how long that you were there?
So I think I was specifically in the hospital for 1 month
What hospital were you in?
at UCSD.
And after you were at the UCSD hospital, where did you go to next?
I think I went to the rehabilitation center.
How long were you at the rehabilitation center?
I think it's approximately around 1 month.
Where did you go after that?
I believe that I went back home to my parents' house.
After your first memory of the rehabilitation center feeling lost, what's the next thing that you remember?
I guess the notable memory that I do have would be the sense of relief and joy of being able to see my room at my house, at my parents' house, would be the notable thing that sticks in my mind at this moment in time.
When you remember being in your room or seeing in your room, did the memories from there get a little bit clearer for you?
It certainly has gotten much clearer than those back in those days. But that being said, I do think that there's also, my memory just in general was very patchy at the time, so there may be some portions that seem much more clear to me than other portions that are completely deleted out of my mind.
Is it fair to say that you learned that you were in a car crash?
Yes.
Did you also have treatment for injuries from that car crash?
Yes, plenty.
What were the injuries that you had?
The injuries that I had a multitude of injuries. So the notable injury would be that my thigh bone, my femur, was snapped in half, and so they had to replace that. And then my hand, as you can see from my scars, that they are my hand was very debilitated, and they had to do surgeries for that to make sure that I still have a hand. Fortunately, I do have a hand. And then the other thing would be, I guess medically speaking, it's called homonymous hemianopia. But that being said,
I'm going to stop you there for a second. So, whenever you use any medical terms, you have the joy of spelling them for us so that the court reporter gets it right. So you used a term, it began with an H. Could you spell that for us, if you could?
Or I can just tell you exactly what it means, but either way, spelling homonymous hemianopia is HOMONYMOUS, and hemianopia is HEMINOPIA, and some people include hemianopsia or anopia. They're the synonyms, so it doesn't matter. So regardless, what does it all mean, right? So basically, that just means the fact that in both my eyes, I cannot see the left side of the world.
And was that injury as a result from the car crash?
Most certainly.
And how did that injury manifest itself? Was there an injury to your head or something like that? How did
Yes.
that come about?
So the other thing that I was going to follow up with is the fact that I had a traumatic brain injury. And that is the main reason why I have the homonymous hemianopia.
And so the traumatic brain injury, did you actually fracture your skull or
So,
what was it?
I think that there were some fractures and they had to readjust my eyes because I had some ocular abnormalities, and I had to do some surgeries for that as well. And so I definitely had some injuries with that. I don't know if there's any notable, I can't recall exactly, what kind of fracture there was specifically, but I do know that my brain was significantly injured from the accident.
Well, when you wash your hair, do you have any scars on your skull that you're
Yes,
not familiar with?
I do have scars on my skull. And granted, that being said, they might not be the most visible right now, but if you look in closer, it's definitely there.
And the scars that you had, were those a result of the crash, or did you have to have surgery to repair some of the damage?
I think they were from the crash, and then, so they were from the crash.
Now, when you were in hospital, is it fair to say that you have no recollection of that month that you were at UCSD?
Completely zero. Either way, I was comatose for I think around 2 weeks, so I would not have any recollection even if I wanted to. And then I was recovering from my comatose state, and I'm not going to have the cognitive ability to be able to remember anything at that moment in time either.
You mentioned also that there was some ocular damage, is that right?
Yes.
Did you have a broken orbital socket at all?
I think they had said something about that, and I had to get some surgeries to basically adjust for that. But I'm not entirely sure exactly the details behind how the ocular surgeries, I think they had said something about how my eyes were misaligned, and so I had to get some surgery for that.
And was all of that happening in that 1 month that you were at the hospital?
I don't think so. But I think some of the surgeries, like the ocular misalignment one, may have been a little later. I can't recall exactly when it was, but yeah. But it should have been after being in the hospital comatose.
So, after the time spent in the hospital, then you go to the rehabilitation center, then you get home. Have you had any surgeries since the time that you were actually released from the rehabilitation center?
So again, this is because of the fact that I have terrible memory around that time, just in general, but I thought that I thought that I had some procedures done for the ocular misalignment and hand surgeries, I think, were a little bit later after being discharged.
Welcome back to Law and Crime. That was testimony from Yuki Izuki. He was a victim of this offense of Jason Riley King driving the wrong way on the freeway that fateful night. We just heard about his traumatic brain injury and sort of the issues that he's still dealing with today. And I'm joined still with Nima Haddadi of the H Law Group. Nima, you represented Mr. King for a short time in this case. What do you make of sort of the emotional impact that testimony like this, like the testimony that we just heard, is going to have on this jury in terms of, leave the law at the door? How are jurors going to react to this?
It's very sad. The entire thing, I feel like it's a very emotional trial, but like I said, my heart goes out to the victims. But even on Mr. King's side, you have a Marine that had never gotten into trouble before, never had any type of incident with the law. It's terrible on that side as well.
Right.
The entire situation is just bad, and it's sad and emotional. I feel like I don't think that the jury's gonna push towards one side, because again, at the end of the day, the law is the law. But on both sides, it's just very sad.
Yeah. Now, I know you're a little bit biased, obviously, but I always like to ask my guests about conviction predictions. What do you think? How do you think this case is going to play out?
I don't think that they're going to get him on murder. I think that it's outrageous. It's very, very tough for the prosecution to get a murder conviction, because it just doesn't match the facts. It's so out of place in this case that I don't know even any other way to put it.
So do you think they'll convict on the lesser included manslaughter?
I do.
Okay.
I do.
Okay. Well, that's interesting if you really believe in this jury's ability to sort of see the forest from the trees in this instance and really put the law ahead of maybe their visceral reactions or whatever emotional ties they may feel from hearing about the victims in this case. Just before we go, Nima, and it's been great having you on. Thank you so much. Tell us a little bit about the appeals process. Let's say he is convicted on both counts of that second-degree murder. Where does he go from there, and what happens procedurally?
An issue needs to come up for appeal. It could be, improper admission, exclusion of evidence, something like that. But again, I just have to keep going back. I would be in shock if they got a conviction on murder. I genuinely would be in shock, because it just doesn't make any sense. And I'm sure that afterwards, if that was the case, there will be a ton of appealable issues.
Yeah, it certainly would be a new legal precedent, that is for sure, which is why, again, it's such an interesting case for us to cover here on the network. Nima, thank you so much for being with us today. Hope you'll come back and join us soon. Coming up at 1 p.m., we have a special segment for you guys on the Mueller investigation. I have a special guest joining me. Until then, I'm going to take you guys back to the rest of that testimony from Yuki